This program is a community education production brought to you by the Bar Association of Montgomery County and the Montgomery County, Maryland Bar Foundation. The program is designed to provide you with general information regarding your rights and obligations under the law. It is not intended as specific legal advice. You should discuss the facts and circumstances of any particular matter with your own attorney and obtain advice specific to your case. The participants are local attorneys who have volunteered their time to bring you this program. We hope you find it informative and beneficial.
Welcome to Law School for the Public. My name is David Schoenfeld, and I am a partner in the law firm of Bonner, Kiernan, Treback, and Crociata. Motor vehicle accidents, we all wish they didn't happen, but they do. Unfortunately, people get injured and killed in car accidents. When accidents happen, we all get nervous and scared. We think we know what to do, but most times things get missed. In today's show, we will discuss what our obligations are. Should we call an ambulance? How about the police? What do you tell the insurance company? Should you hire a lawyer? We will discuss what to do if you're involved in a motor vehicle accident. To answer these questions, we are fortunate to have with us two attorneys extremely knowledgeable in this area. Charlie Chesney is a partner in the law firm of Beddoe and Noble. Charlie is a graduate of the University of Maryland and obtained his law degree from the University of Baltimore School of Law in 1991. Charlie represents individuals, businesses, insurance companies, governmental organizations, and self-insured entities in the defense of insurance matters, premises liability cases, automobile negligence, workers' compensation defense, and construction litigation matters. Charlie is a trained and certified civil mediator and has volunteered as a judicially appointed settlement conference officer. Charlie has been a frequent speaker at educational conferences and at the educational sessions of many professional organizations. Louis Silber was born and raised in Montgomery County, Maryland, graduating from Springbrook High School. Louis is also a graduate of the University of Maryland and also obtained his law degree from the University of Baltimore School of Law. Louis is the founding member of the Silber Law Group. Louis's practice includes representing individuals charged with crimes and assists individuals in civil litigation matters, workers' compensation cases, premises liability matters, and contract disputes. Louis volunteered significant time both to the Montgomery County and Prince George's County State's Attorney's offices, helping individuals. Louis is a frequent speaker at educational conferences of many professional organizations. Mr. Silber has been awarded one of the 10 best attorneys for the state of Maryland by AIO-CLA. Louis, Charlie, welcome to you both.
Thank you.
Thank you, David.
Thanks for having me.
Charlie, tell me a little bit about your practice. What is it that you do?
Well, I am, as you've said, partner in the law firm of Beddoe and Noble. We have offices in Bethesda as well as Howard County, very near the courthouses. What we do is what's called insurance defense law. So if a person is injured in an accident and files a claim or contemplates filing a lawsuit, that would be against an individual or a business. So I would represent the business or the individual in defense of that claim. Primarily what I do and what we do in our firm is to handle personal injury matters. We do some property cases as well, involving arson or accidental fires, loss of property only. But certainly we deal with some heavy-duty cases involving personal injury. People may have permanent injuries as a result of a motor vehicle accident or a slip and fall at a residence or at a commercial property. So we handle those types of things. We also represent the insurance companies directly when they are accused of doing something that's not quite right in the handling of the claim. That's what's called a first party, when the insured has a beef with their own insurance company. Then third party is where the insurance company is defending against someone outside of the insurance contract. So that's essentially what we do. We're in trial all the time, and we're very fortunate to have some very large and very loyal clients over the many decades that we've been in practice.
Good. And Louis, tell us a little bit about what you do.
Well, I'm kind of on the opposite side of what he does. I do plaintiff's work, which means when somebody gets injured, I represent them and their claim for injuries they might have, and we're going against the insurance company. So I'm in court quite often as well because he's in court quite often. So a lot of times we can't resolve these cases favorably. either because they're not compensating what the client wants, enough money, or maybe they don't believe what their injuries are, or maybe they don't believe their injuries are substantial as the client thinks they are. So we'll end up in litigation a lot with that as well. We also handle property damage claims. I also do a fair amount of criminal defense work. We may get into that as well, because some of these things that happen when an accident occurs do tie into criminal aspects also, the criminal defense area.
So that's a good segue. So an accident happens. Unfortunately, they do happen, and some of them are much more serious than others. But what are some of the things that you tell your clients to be careful of when the accidents occur?
Well, the first thing you got to do is obviously make sure you're okay, and make sure everybody involved in the accident's okay. You want to make sure that there's no really serious injuries, and if there are, obviously call 911, get an ambulance there. The next thing you want to do is make sure you stay at the scene. Sometimes you leave the scene and the other party thinks you're actually leaving. They call the police, and then you get charged with a hit and run. That's sometimes
which
turns
is a
into
criminal
offense, and that's a jailable criminal offense. When there is even property damage to another vehicle, it's a criminal offense. You can also, there's also people charged with DUIs several times. If the police come to the scene and one of the drivers has been driving under the influence, they smell alcohol, you can be arrested for a DUI, even if you're not at fault for the accident.
What about calling the police? Do you have to call the police?
You absolutely don't have to call the police. I think it's a good idea, and I think my colleague here will agree with me, that it's a good idea to call the police. However, they won't always make a report unless there's injuries or unless a car gets towed. If there's no injuries, there's no significant property damage, and the cars are drivable, they'll usually just tell you to exchange information and then move the cars off of the road.
And Charlie, some of the things that you look for, the insurance company calls you up and said, investigate this accident, something's not quite right. What are you looking for?
Well, keep in mind that by the time an attorney is brought into the case by an insurance claim representative, there's been a significant amount of investigation that's occurred already. There may be settlement efforts that have been undertaken either with a person who is the plaintiff who's represented by counsel, or somebody who's not represented by counsel, but the two parties on each side, the insurance company and the injured person, couldn't get together on a number that they both thought was reasonable and acceptable. So then it comes to my office, often once suit is filed. Now, when a lawsuit is filed, we receive all of the claim documents that come from the insurance company. Those are log notes and recorded statements and police reports if they were there, information that was exchanged, photographs, scene diagrams, that sort of thing, witness information. So we receive all of that, we review that, and we prepare a preliminary evaluation and analysis of the initial evidence that's there. So what I'm looking for are precisely those things. Recorded statements are invaluable. They can come.
Who takes the recorded statement?
So my insurance company, if I were being sued, or if I were the injured person, would likely call its own insured and say, we need to document our file about what happened. And at that time, you have a choice. Now, if it's your own insurance company, you really do not have a choice by contract because you're required to cooperate with your insurance company. So when your own claims representative calls, and you can verify that by asking them, they'll say, can we take a statement? The answer should be yes. If it's a good time, if you're not on medication that makes it difficult or impossible for you to recall or to stay awake, frankly, or if you're in too much pain and it's the sort of thing that you can delay. And maybe they'll call back, maybe they won't. But if it's your own insurance company, you have an obligation. So you want to give them the information. You'll be instructed that it's a recording. They'll tell you when it starts and when it stops. They'll try to get the information from you. In preparation for that, you really want to have the information at hand. What notes did you take? Did you get any witness information, any party information from the other person involved in the suit? Who was with you in your own car? What time of day? What was the weather like? Think about those things in advance. And give your own insurance company a statement. Now, if the other insurance company calls...
Well, that was what I was going to ask Lewis. So your client comes to you after the car accident, and this guy's calling me from the insurance company, Charlie's insurance company. Do I have to talk to them?
Absolutely not, and you don't want to speak to them because, and I want to get back to the scene a little bit at first. You got to be very careful of what you say about how you feel and what you say about fault. Sometimes fault, the average layperson doesn't know whether they're at fault or not. It might be a legal analysis that somebody has to determine at a later time, and you may say something wrong that may affect you later on. Likewise with your injuries or the way an injury happened. The typical example I can think of is if you tell a representative from an insurance company, well, I was hit from the rear and my body went forward and then backwards. Well, the laws of physics tell us that's not how it happens. Your head would snap backwards and then forwards. But the insurance companies use that later against the client perhaps to say, well, this person's making an injury up, or maybe their injury is not valid because they didn't really say the mechanism of injury, how it really happened, because they said their head went forward first, and that's not really what happened, even though they thought in their head that's what it did.
What should you say to the other people involved in the car accident? I mean, you have to go up to these people to see if they're okay.
Sure, you ask them if they're okay, and you know what, it's perfectly okay to say, I'm sorry that an accident happened. I'm sorry doesn't mean you admit fault, and we go through that all the time in court. Did the other person say I'm sorry? And nobody's persuaded by I'm sorry anymore. So you don't admit fault. You can certainly make sure they're okay. I'm sorry the accident happened. You exchange information, and that's it.
Well, and what information do you have to give them?
Well, your name certainly, your address, your insurance information, things like that.
All right, so what happens if the person on the other side, and this does happen, it's their brand new baby, and you just ran into it, and they're not so happy, and you're a little scared. What do you have to give them? Do you actually have to stay there? And what if the person's a little bit violent? What is it that you do?
I'd hand this over to Charlie, but I would call 911 at that point and make sure you would get somebody involved that has some authority. If you're really frightened, you definitely don't want to leave the scene because that's something you can't do. You have to stay at the scene legally. If you really are frightened, then you should call 911 and have somebody get there.
I'd have to agree with that. You know, you could maybe carry some nunchucks in the car with you, but then you may find yourself being represented by this gentleman in a criminal action. So really what you want to do, and of course, the obligation is to stay at the scene and to exchange information. But if somebody's violent, look, you then have an excuse under the law to say, I've got to get out of there. But while you're doing that or after you've done that, call the police. Let them know what happened, where the injury occurred or where the accident occurred, and let them know so they can handle it. Look, we should not be taking the law into our own hands, and road rage is a terribly dangerous thing that people, you know, can get very badly hurt.
And the 911 calls, if you call 911, it's recorded, correct?
It is.
So if you're concerned about it, you can make the call to 911, and at least there's a record that you were there, you wanted to stay, there was a concern, and you're now leaving.
I was going to follow up on what Charlie said before. Documentation is really the key thing about these because later on, what always comes up is really what did the person do and what would the reasonable person have done at that time.
What about pictures?
Pictures are a great thing. We used to tell people keep a disposable camera in your car, and now everybody pretty much has a cell phone with a camera on it. It's really not hard to take pictures or even a video. Definitely of the scene, definitely of the cars, of damage to both cars. Any intervening causes you think may have contributed, such as maybe there was something blocking your view or something like that. Everything around that you think might be pertinent.
If you're injured, and do you go in the ambulance? What if you say no? Should you say no?
I don't think you should ever say no if you're injured, because unless you're a doctor and you can evaluate yourself, I always err on the side of caution. If there's any kind of injury at all, anything you feel at all, I always err on the side of caution and say go to the emergency room, at least get checked out, and let a professional decide if you need x-rays, if something's broken. Charlie mentioned before that they handle a lot of defense for serious permanent injuries. There are also sometimes you have things that aren't so serious. It doesn't mean that you have to have a broken limb. A lot of people think that you need a broken bone or you need something bleeding in order to get checked out. That's simply not true. Many times, I have clients that have what's called soft tissue injuries. It's neck and back pain. They have neck strains and neck sprains and of the back, and they need medical attention. And there's absolutely nothing wrong with going to get checked out and letting a professional tell you if you're okay and if you're going to need follow-up treatment.
So Charlie, the hurt individual, doesn't yet have a lawyer, calls maybe your client, and they talk to the adjuster to try and work out a deal. Do they need a lawyer? I'm asking you because he's going to say yes, but do they need a lawyer?
It depends on how sophisticated the individual is. It depends a lot on the seriousness of the incident and of the injury. For example, if I'm struck in my vehicle and I decide to go to the emergency room, I drive myself there, the doctor checks me out and said, well, at most you might have something soft tissue. The x-rays show no broken bones. You're in fairly good shape. Good thing you got checked out. Certainly I would agree with Lewis that you need to get checked out. You document, for the purpose of litigation, you document that you actually did get checked out, and you find, the findings are reported and your complaints are reported. But when something more serious happens, you need to be cautious about, first of all, talking about settlement to begin with. You never know what sort of injury you have until some time passes. You never know how long your injury is going to take to heal until some time passes. So it's way too early to talk about settlement. In fact, it really, the law would say that if there's an early settlement, before really all of the facts are known, that is presumptively improper and will be stricken by the court and nobody will have to abide by it. So that's something to keep in mind. Now, whether you retain counsel or not, again, depends on your sophistication, your experience maybe with this sort of thing, your level of injury, property damage possibly, whether the other side is insured. If they didn't have any insurance, you've got a real problem on your hand because they probably couldn't afford their insurance premium in the first place, which means there's not going to be much in the way of damages for you. It might be a long haul situation. So give some serious thought to that.
So under the policy, let's say they're not insured. Will your policy pay for that?
Yes, fortunately, the legislators of this state and most, if not all states, have what's called uninsured motorist coverage that's part of the actual insurance code, the statute.
And what does that pay for?
Well, what that pays for, if I'm struck by a vehicle that's not insured, then my own insurance company has a part of it. In fact, you're buying a lot of different types of insurance when you buy an insurance policy. So you're buying that uninsured motorist coverage, and it will be up to the same limits of coverage that you have. So if I have $100,000 worth of liability coverage, meaning if I'm at fault and I have to pay somebody else for their injuries, then initially my UM, or uninsured motorist coverage, will be at that same level. So I actually am adverse to the person who struck me, but in a way, my own insurance company is their insurance company covering their damages. Now, that insurance company can also go back against the person that struck you to get their money back.
But you get paid.
Correct.
Okay. And so what's PIP?
PIP is personal injury protection, and that's something that you can purchase as a part of your policy. You can also waive it if you'd rather not. Some people say that they've got plenty of health insurance and they don't have a high deductible plan, so they're really covered for their auto accident injuries. But you can purchase as a part of your policy personal